Welcome back to Chazin-the-Dream. I'm Ethan Chazin, a New York-based organization development coach. I'm so excited to have Steve Trimboli here with us today as our guest. And just a little bit of background about Steve. Steve is a labor, employment, and regulatory compliance and reputation defense attorney for businesses and nonprofits and public entities in New York, New Jersey, Washington, D.C. Steve's a graduate of the Johns Hopkins University and the New York University School of Law, and founding partner of Trimboli and Pruzanowski, headquartered in Morristown, New Jersey, and with offices in New York City. So let's dive right into Chasing the Dream. Steve, welcome to the program.
Oh, thank you for having me, Ethan. I'm pleased to be here.
Our pleasure, as always. So let's dive right in. You and I were talking previously about your 40 plus years in the law and your focus on employment law. And you said something to me that was really interesting. You talked about this tension, right? This tension of what we should do and what its impact is. And I was wondering if you could kind of share a little bit more insight on that for folks.
Oh, sure. What we have seen over the past 40 years is this change in areas of employment law in particular, where it used to be the focus was on formal actions taken by the employer, hiring, firing, promotions, transfers, and things of that nature that were official acts of the employer. When sexual harassment first became an issue in the late 70s into the early 80s, the focus changed. Now the work environment became deemed a term of employment, and the employers now were potentially liable, not for things they did in their official capacity, but for allowing hostile work environments to exist or allowing harassing conduct to take place. And now they needed to take corrective action. And as often is the case, seeking to avoid liability, employers adopted policies and procedures that, when you read them, seem like the old censor codes from the late 19th century. And as you may know, the acronym NSFW, not safe for work, has become an internet joke because employers now are responsible for basically maintaining a workplace that is G-rated and avoiding and making sure that there's nothing that can be deemed a hostile work environment between employees or between employees and between supervisors and employees. And in some cases it has a chilling effect. And one particular chilling effect I've seen over the years is supervisors who are afraid to supervise, because as part of those policies, the employers have now been provided with or employers have been providing policies for employees that give them a roadmap for going over their supervisors' heads and bringing forth complaints, which on the one hand were necessary to bring to light actual acts of discrimination and misconduct by a supervisor, but also now put supervisors out on an island because they're responsible for supervising. But if the employee files an objection, the employer is not necessarily going to stand behind them. They're going to now subject them to investigations. And even if the supervisor is cleared, nobody likes being investigated.
This is really fascinating to me because my perspective, my position as an organization growth coach is to create these cultures that don't have a necessity for what you're talking about, which is harassment and a kind of non-hostile work environment. So I hear what you're saying about the shift in thought process, but from your perspective, how do organizations change their culture so that these kind of hostile workplace environment and litigious actions don't occur? Like, how do they get ahead of this?
Well, there's a couple of things. First of all, again, another change I've seen over the 40 years is that going back to the early 80s, when I came out of law school, there was still this command and control attitude in the workplace that they were the boss, you were the hired help. There was a clear line between the two, and your job was to do your work, follow instructions, collect your paycheck, and go home. That has changed significantly, and now there's and great emphasis, what I'm sure in your practice you've emphasized, of cooperation, of supervisors not being so much bosses as coaches and
Right.
facilitators whose job it is to make the subordinates excel. I think that's is the first place you start, because if that's your attitude as a supervisor, then you're not going to make offensive comments, and you're not going to do the things that can get an employer in trouble, because you understand that's not how you build a team, and that's not how you support others. So that would be the first place. Second, I think there's an understanding that, yes, the workplace is a serious place to be. If you want to joke around in a horseplay type of sense, and engage in the old boy network type of joking, do that on your own time. Don't do it at work. And there's also something to be said about sensitivity to others. You don't necessarily go full on in the diversity and equity and inclusion that is becoming increasingly important, but you do understand that other people may not perceive the world the way you do, and at least take that into consideration in how you deal with them. I think those are three key steps that you need to have a cooperative and thriving workplace. But
You,
again,
you know,
oh, sorry.
no, no, go.
The key point being that as a boss, your job is not to put up your feet and just give orders. It's to facilitate the performance of your team. And if you're responsible for the team's performance, you have to understand that you succeed if they succeed.
It's really fascinating to me because you may be, Steve, quite frankly, in all my decades of doing this, the only attorney I've ever heard in the field of employment and labor law talk about one of the fundamental shifts you've seen is this change in command control, where the leadership team is in control and employees have a very specific scope of relationship. And now what I'm hearing you say is the dynamic is changing in terms of the employee-employee relationship, where it can't just be the old boy, white, boomer, mature firm environment, but with diversity and more attorneys from diverse backgrounds coming into the workplace, there needs to be a requisite shift in mindset. And I guess that's just fascinating to me to hear, because that's not something I've heard before, quite frankly.
Well, as a white male boomer, it's kind of interesting that you put it to me that way. But it's more than just that, though. Even if it was just a collection of white male boomers, or white males generally, the change is this notion that we are not here to give orders and demand performance. We are here to coach. We are here to encourage. We are here to make it possible for the people who report to us to succeed. And yes, it does take into consideration some of the items that you've discussed, but it's also broader than that. It's a genuine understanding that the team works together and everybody has their role and their place, and that they support one another, as opposed to the command and control model that was certainly in place when I was a young lawyer, when there was no mistake that you were hired help and nothing more than hired help. All that does is send people out with resumes looking for new jobs.
Correct.
And the entities, the employers that succeed and keep their turnover rates low, are employers who avoid the kind of issue. And it's not only a case in law firms, it's a case with clients we represent, some the nonprofits we represent, and nonprofits on boards I sit. We're proud to point out that our turnover rate is significantly lower than the economy as a whole, and even in the industry. And the reason for that is we have the kind of work environment that or they have that kind of work environment that I described, where it's teamwork, and the supervisors understand they're there to hold people accountable, but also to facilitate their success, as opposed to simply saying, here's the target, meet it or else.
Every time we talk, I get really interesting insight from you, because it's just so far beyond just merely the legal perspective. But I do have a question in that scope, in terms of law. You had mentioned when we spoke previously about some really, I forget the exact words, but I'll just call it interesting client employment horror stories.
Yeah.
And without revealing, the names shall not be revealed to protect the not so innocent. Do you have any fascinating stories that kind of shed insight into the dynamic of creating a more equitable culture to kind of minimize some of the legal risk?
Hmm. Um, well, one horror story is when you have a client who, despite all the changes in the workplace and all the publicity about harassment, hostile work environment, still had a unit where they were putting girly pictures on their locker and making rough jokes and not providing their female employee with a facility where she could take care of personal needs. Um, that is, I mean, that's an obvious one. Some other horror stories, and this is slightly different, um, is where you have two employees who don't get along or having a personal conflict, and one of them chooses to bring a complaint and color it as harassment or discrimination. Um, there are many cases where the better approach is a sort of counseling, coaching approach. But when it goes immediately to an investigation mode, then battle lines get drawn, positions get hardened, uh, and sometimes it takes a little bit more finesse to handle these matters properly, uh, which is a good reason why these types of workplace investigations, if they are necessary, should be handled with somebody who, or by somebody who's experienced in investigations, because they can handle the matter with judgment and discretion and not be accusatory or not be or suggest that somebody was wrong before all the facts are in. And can help bring the matter to a more equitable and fair and ultimately long-term solution rather than uh, becoming confrontational and immediately imposing discipline. Because in some of these cases, discipline isn't warranted. In some of the cases, it truly are misunderstandings, or they are, or both sides are somewhat at blame, and the things that we would think of as illegal harassment based on a protected characteristic simply aren't present. And those matters should be dealt with more as coaching matters rather than as discipline matters.
This is really interesting to me as well. Could you kind of talk a little bit about the framework of the process whereby an organization may say, we want to handle some of this conflict, we want to work towards resolution of it internally. We want to do this ourselves to kind of mitigate risk. And then they get to the point where they realize that we can't resolve this internally. And to your point, then it's best for them to seek outside expertise when you get to an investigation. So what's the transition typically from your experience look like?
All right. It starts with a review of their internal policies and what they have decided, the way they have decided to handle these types of complaints. But I can give you an example of what we have seen in our practice is a complaint comes in and it's worthy of investigation or needs to be investigated under the employer's policy. And they'll give me a call. What I will do is bring in an outside investigator, and human resources consultant who's experienced in investigations, and have that person conduct the investigation and then provide me with the statement of the witnesses' statements, a write-up of the documents reviewed, and a summary of what he or she learned during the investigation process. I will then make an assessment about whether there's a potential legal issue, whether there's potential liability, whether the conduct as alleged amounts to a violation of law, or whether it's a personnel issue that should be handled in a different, as I said, in a coaching way. In situations like that, we have recommended business and workplace relations coaches to come in and work with the persons involved and try to resolve the matter in a cooperative way. Because in a situation like that, if there's no illegal conduct or no violation of policies, and it's two individuals who are having tension in the workplace, taking disciplinary action against one is not really going to solve anything, because it's going to cause lasting tension. And the idea is, let's try to resurrect this relationship. So even though they may not be best of friends, they can get along with one another, work together, and put their issues behind them. So that would be an approach to try to resolve the issue without getting into discipline, and also without running a risk of a lawsuit, because if somebody does later bring an action, you can legitimately say, hey, look at the actions we took to try to resolve the issue. And that would be either someone who's dissatisfied and still feels that they have a claim, or if disciplinary action is taken against somebody and they try to raise a claim based on the discipline, again, we can say, hey, look, we worked with you, we tried to resolve this, and the end result was nothing changed, or you didn't improve.
And so you've got the process that you've navigated with the client, but also they've got a measure of protection that they can say, look, we took a course of action. We didn't let this hostile situation exist. So it's covered. I guess if we could shift gears a little bit, because I'm fascinated also with how that you decided, when you came out of law school, that you said this area of the law is really interesting to me, and what is it about employment law that's kept you engaged over the decades? As you said earlier, things have changed significantly in the field, but what is it that drew you to this?
Well, candidly, when I was in college and law school, the employment practice was predominantly labor law, which is management and labor relations, dealing with labor unions, National Labor Relations Act, unfair labor practices. And that was always an interesting area to me. I always wanted to be on the management side, but the idea of collective bargaining, negotiation, dealing with strikes, dealing with unfair labor practices, dealing with a practice in front of a specialized administrative agency was appealing. As the years went by, union practice became a smaller and smaller part of the overall employment practice, because the union membership declined. And in its place was this never-ending parade of legislation dealing with employment. And that slowly but surely took over the employment practice, where it is now predominantly advising clients on employment law issues, dealing with potential employment law claims, defending employment law claims, and keeping clients updated on the ever-changing areas of law involving employment. Just recently, New York City passed an ordinance making it unlawful to discriminate on the basis of weight and, I believe, height. So that's another issue that employers need to deal with. Other areas that are becoming contested are non-compete agreements, non-disclosure agreements. We have federal agencies challenging the legality of each of those categories, which historically have been subject to state regulations through the courts. Independent contractor versus employee with the gig economy. Governments who are very interested in continuing to receive unemployment taxes and employment taxes are cracking down on what they perceive to be the abuse of the independent contractor relationship. Whether that is or is not abuse is open to question. If we had time, I can explain to you the 7 different tests that are used to distinguish employers and independent contractors. We attorneys can spend the rest of our natural lives arguing about where that line is. Expecting an employer to figure it out all by itself is sometimes hard to understand. But those are the predominant issues we see. There's still labor practice, predominantly in the public sector, but still somewhat in the private sector. We still put our skills in that particular arena to use on a regular basis, but it is nowhere near what it was when I came out of law school. And you asked the question, what gets me out of bed in the morning? And
Yeah.
keep me interested in this is the fact that, number one, the law is constantly changing, so it doesn't become rote or boring. Number two, it's one of the areas where we can say, like the old commercial, we're not only business owners, we're also a client, because we are also employers and we also were formerly employees ourselves. So we understand how that relationship works. We understand what employers in all industries go through. Yes, there are things about law that are unique, but there are things about your business that are unique, and there are things about every business that is unique. As you pointed out, we practice in three different arenas: the public sector, the private sector, and nonprofit sector. Each one of those sectors responds to their own incentives. In the private sector, it's the bottom line and profitability and keeping costs down. In the public sector, it's donors and grantors, and that's the nonprofit sector. And in the public sector, it's they respond to political incentives that don't apply in the other two sectors necessarily. And our challenge is to address their employment law issues, bearing in mind the unique worlds in which each of those three separate entities exist.
Yeah, this is really fascinating to me because, as you said, you've got this view, this perspective, which is you've spent decades in employment law, and you are also an employer. And I'd love to know your thoughts in terms of how you, for lack of a better word, internalize that expertise, that experience, kind of working with clients in those three realms
Yeah.
about how they best handle their employment matters. How do you take that home, so to speak, in terms of building out your law firm and how you go about your relationship with your employees?
Well, it is essentially a case of us practicing what we preach. We start out by, we are not the command and control old-fashioned firm. We're not a firm where if an associate cracks a joke with the partner, the associate's fired within a week. The types of firms that I saw when I was younger. We are not simply a firm that expects an attorney to bill hours and be satisfied and then go home. We understand that it's a team approach, and that our job is to create an environment in which the younger attorneys and the staff can succeed and take and go where their abilities and talents and desires lead them. And two, we understand what it is we can and cannot do as employers, and how we can and cannot behave around our staff and associates, and we act accordingly.
Yeah. Isn't that a novel idea, though? Is to
Mm.
treat people the way that they would want to be treated, with the notion that it's not just about coming into your law firm every day and at the end of the week it's billable hours.
Right.
It's not 80 or 90 hours billed this week, that there's much more. I'm keenly aware of, over the decades, you talked about a shift in the workplace and, employment law kind of following. I'd be remiss if I didn't point out that we have seen tens of thousands of boomers and matures leave the workforce now on a regular daily basis. And the workplace in all those three realms of government, public, and private are being filled with millennials and Gen Zs coming in. And so the nature of the workforce is shifting. And I'm curious, any last kind of thoughts you have about employment law following suit with that changing dynamic of the greater cultural and generational diversity of the American workforce?
Well, in the popular press and in the media, we're seeing that we're told that the younger generation is coming in with different attitudes toward work and different expectations, and about what they expect from the workplace. I've heard complaints like that from clients and others that I deal with. I have to tell you, my personal experience doesn't support that. The younger attorneys that we've dealt with over the years, in some ways, are more serious about the workplace than we are. I I remember one particular Halloween, there was an article that Sherm put out about improper, how to deal with people who wear improper costumes. And I circulated around the office. I had two associates come in and say, why would anyone wear a Halloween costume to work in the first place? This is work. This is a workplace, which is kind of interesting from the younger generation that's supposedly less serious than we are. The only other observation I would add is that going back to the mid-90s, when we had the dot-com boom, I was hearing similar arguments that younger generation was different, and we had better change our attitudes, and no one's wearing suits to work anymore. And I heard someone say this at an event I attended, and my response was, let's see what happens when the economy changes and the unemployment rate creeps up. Shortly thereafter, we had Enron, we had the dot-com crash, unemployment, we had a short recession, unemployment went up. I saw an article in the New York Times, business suits are coming back into style. So some of this may be permanent, some of it may be cyclical, only time will tell. And I also have a sense that millennials, when they start having to pay bills and maturing and becoming further acquainted with professional life, their attitude may change too. I saw it happen in my generation. I have no reason to suspect it won't happen here.
Well said. So true. Listen, Steve, I wanted to reiterate how much I appreciate you appearing on the program. And if anybody has heard what you said and they say, you know what, I really want to talk to Steve a little bit more about some of the things we've discussed today, how can they get in touch with you?
Sure. One way to get in touch with me is with my email address, which is Trimboli, STRIMBOLI at trim, TRIM, PRU, law, LAW.com. My cell phone, which I use as my direct line, is 201-400-7597, or you could check out my LinkedIn page.
Yeah. And by the way, I will put the link to your LinkedIn page and your firm's website, below. So no worries about getting that covered. So listen, again, thank you so much for appearing on Chazin-the-Dream. And it was a pleasure hearing from you, Steve.
All right. Thank you for having me. It was a great discussion.
Thank you, Steve.